Hello and welcome to the Minimum Competence episode for Monday, May 18th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, Amazon's tariff refund suit, the Federal Circuit's theme song and guest judges, and Trump dropping his IRS lawsuit. Let's remember, learning is the quiet work that turns curiosity into confidence. And read today's legal news. On this day in legal history, May 18th, 1896, the U.S. Supreme Court decided Plessy v. Ferguson, a case that became one of the most infamous constitutional decisions in American history. The dispute arose from a Louisiana law requiring separate railroad cars for black and white passengers. Homer Plessy, who was of mixed race, deliberately sat in a whites-only rail car to challenge the law. After he was arrested, Plessy argued that the statute violated the 13th and 14th Amendments. The Supreme Court rejected that argument and held that racial segregation did not violate the Constitution as long as the separate facilities were considered equal. This became known as the separate but equal doctrine. In practice, the doctrine gave legal cover to segregation across the South and helped support the broader Jim Crow system. The court treated segregation as a matter of public policy rather than as a badge of racial inferiority imposed by law. Justice Henry Billings Brown wrote the majority opinion, reasoning that enforced separation did not necessarily imply inequality. Justice John Marshall Harlan dissented, warning that the Constitution should be colorblind and that the ruling would become as harmful as the court's decision in Dred Scott. His dissent later became one of the most important statements in American civil rights law. For nearly 6 decades, Plessy allowed governments to maintain racially separate schools, transportation, and public facilities. The decision was finally undermined in 1954 when the Supreme Court decided Brown v. Board of Education and rejected segregation in public education. Plessy remains a stark example of how constitutional interpretation can either protect civil rights or help entrench systems of inequality. A proposed class action filed in Washington federal court accuses Amazon of keeping money it allegedly collected from customers through prices inflated by now invalidated Trump administration tariffs. The plaintiffs say Amazon could seek refunds from the federal government after the U.S. Supreme Court struck down the tariffs, but has refused to do so because it wants to stay in President Trump's good graces. The lawsuit claims Amazon passed tariff costs on to shoppers, then failed to commit to returning that money, even though other retailers have allegedly pursued refunds. The customers point to Amazon's abandoned plan to show tariff-related price increases on product pages as evidence that the company can identify both the tariff amounts and the consumers who paid them. They also claim Amazon backed away from that plan after criticism from the Trump administration and a call involving Amazon CEO Jeff Bezos. The complaint alleges violations of the Washington Consumer Protection Act, unjust enrichment, and money had and received. The plaintiffs say Amazon misled consumers by suggesting tariffs were not increasing prices, while allegedly raising prices on certain low-cost goods after the tariffs took effect. They also argue Amazon failed to tell customers it would not seek tariff refunds even if the tariffs were later found unlawful. The proposed class would include Amazon customers who paid tariff-related surcharges from February 4th of 2025 through February 20th of 2026. The suit estimates the class could include tens of millions of buyers and seeks to recover money the plaintiff says belongs to consumers. Similar lawsuits have been filed against other major companies, including Nike, Sony, Nintendo, Costco, Temu, and FedEx. The Federal Circuit held its biennial judicial conference in Washington, D.C., bringing together its active judges, agency leaders, district judges who have recently sat by designation, Chief Justice John Roberts, and Solicitor General D. John Sauer. Chief Judge Kimberly Ann Moore opened the event with lighter moments, including praise for Senior Judge Raymond C. Clevenger and the debut of an AI-generated Federal Circuit theme song meant to make the court feel more accessible. The conference did not address the ongoing suspension of Judge Pauline Newman, although she attended the event while continuing to challenge the suspension at the Supreme Court. Judge Moore said the court issued 630 opinions in 2025, its highest total in a decade, and noted an effort to use fewer one-line Rule 36 affirmances. Still, court leaders and practitioners criticized Rule 36 decisions, especially because they give lower courts and litigants little explanation. The judges also discussed en banc arguments, emphasizing that lawyers must stay focused because full court arguments leave little time for extended exchanges with any one judge. A major theme was the renewed use of district judges sitting by designation, with 23 visiting judges helping decide nearly 200 cases since February of 2024. Visiting district judges said the experience gave them a new appreciation for appellate work, the quality of Federal Circuit advocacy, and the process of narrowing trial records into appealable issues. Federal Circuit judges also described sitting in on other courts, including in criminal sentencing matters, which several said gave them a deeper appreciation for the workload and human stakes faced by district judges. The judges offered practical advice to lawyers, urging them to narrow issues, address weaknesses directly, provide full context for citations, and make appropriate concessions. USPTO Director John Squires also appeared and defended his approach to discretionary denials of inter partes review petitions, saying he's returning the process to what Congress intended under the America Invents Act. President Donald Trump has dropped his $10 billion lawsuit against the IRS and Treasury Department, a move linked to discussions about creating a $1.8 billion compensation fund for people who claim they were unfairly investigated by prior administrations. The court filing did not describe any settlement, but Trump's lawyer said the case was still early enough that he could dismiss it without court permission or IRS approval. The dismissal was filed with prejudice, meaning Trump cannot bring the same claim again. Trump and his sons filed a lawsuit in January accusing the IRS of failing to protect confidential tax information after his tax records were leaked. A former IRS contractor, Charles Littlejohn, was sentenced to prison for leaking Trump's tax information, as well as records belonging to many others. Trump brought the case as a private citizen, not in his official role as president. The federal judge overseeing the case had already questioned whether a sitting president could properly seek personal monetary damages from an agency inside the executive branch. The dismissal follows settlements in lawsuits brought by Trump allies, including Michael Flynn and Carter Page. Shortly after Trump's filing, House Democrats submitted a brief accusing him of self-dealing and arguing that any attempt to use the court process to support a settlement should be closely reviewed. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes, an email, newsletter, form. We'll see you back here tomorrow. And until then, remember, the last day of school is the first page of summer.
Well, it started with a law back in 82. Federal court, some improvement act came through. Congress said we need a brand new way to bring some consistency to cases every day. They merged some courts, made a brand new seat, a national court with a special beat. Not by region, not by state, but by subject matter, keeping ruling straight. Oh, I'm the Federal Circuit, hear me say, I handle special cases from across the USA. Patents, claims, and veterans are appeals, international trade and government deals. When inventors say, hey, that's mine, I review those patents and draw the line. If it's trademarks too, I'm in the mix, making sure the law stays uniform and fixed. From the Court of Federal Claims, you'll see our appeals come up the chain to me. Veterans seeking benefits fair, I review each case with thoughtful care. Federal workers bring their cases along. From board rulings, I decide right from wrong. And if trade crosses oceans wide, I help decide what rules apply. Oh, I'm the Federal Circuit, hear me say, I handle special cases from across the USA. Patents, claims, and veterans are appeals, international trade and government deals. Now you might ask, who wears the robe? Who gets to judge cases we know? The president picks, that's how it's done. Then the Senate confirms each one. They serve for life to stay independent and fair, applying the law with the utmost care.